Me again, I'm sorry, my lord. I'm going to eat into Mr. Hopkins' time very, very briefly to deal with two matters. First, the Master of the Rolls asked for copies of Schedule 3 to the 2004 Act in a comprehensible version. We do have those in the bundles. The Schedule 3 appears in volume 28, which is called Second Supplementary Authorities Bundle, volume 2, 28, at tab 37, page 1400, and the schedule starts at 1401. That's the version applicable in these cases, and your lordship will be able to see the new version as amended by the 2022 Nationality and Borders Act at the next tab, tab 38, starting at page 1413, which has the up-to-date version.
Thank you very much.
Subject to anything further the Parliament may do. So that's the current version. Secondly, and very briefly, the question put to me by my lord the Vice President. Your Lordship is absolutely right. 345 B and C do not deal with the European Convention issues, nor does 345 D. It's not designed to deal with that. The basis for Strasbourg Convention, European Convention points, is Section 6 of the Human Rights Act. That's the obligation on the Secretary of State. There's a right of appeal that removal would be unlawful for human rights reasons. That's Section 84(1) of the 2002 Act, Volume 29, Tab 4, page 29. But that, of course, is disapplied, that right of appeal, if there is certification. That's Schedule 3 to the 2004 Act, paragraph 19C. That's the way it works. I am instructed, and that's why there's a separate human rights decision, as your lordship has seen. For example, in AAA, volume 7, tab 16, page 631, refusal at paragraph 159, certification paragraph 162.
So you're saying all human rights points, there might in some cases be Article 8 points, and
yes.
There are Article 4 points too.
Yes.
None of those come under, are fall to be considered by the Secretary of State under 345A to 345D.
That's my understanding, yes.
Right, okay.
I hope that answers your lordship's question.
Thank you.
Thank you very much, my lords. Over to you.
Yes, Hopkins.
My lords, I will make some very brief, necessarily brief submissions on SAA's data protection ground, which, as you know, is ground 23 in the composite list. The grounds goes to that section of the Divisional Court's judgment beginning paragraph 127. I will adopt what we say in our skeleton argument from paragraph 98 onwards. I will make some supplementary points further to our skeleton argument. What I will do is give your lordships a number of page references as we go, but in view of the time, I won't take you to anything unless your lordships need assistance. Now, having listened to my learned friend Mr. Gill develop SAA's data protection case orally yesterday, and having considered the supplementary notes that he provided at 9 a.m. this morning, my first...
Sorry, I haven't seen any supplementary notes.
I think we've been given them.
It's a two-page
Yes.
note.
Yes, they need to be sent electronically. They have not been. Have they sent? Okay, my JA is sending it. Sorry.
I've seen it but not read it.
That won't be a problem for the purposes of my submissions, though your lordships will, of course, read it afterwards.
Yes.
Having considered the way SAA develops his data protection case, my first supplementary submission is this, that SAA's data protection case is not only wrong, it is so ambitious as to be entirely unrealistic. Now, this is not an attempt by the Secretary of State to sideline her data protection obligations. Rather, the point is that one needs to be realistic about the consequences of any failure to comply with those obligations. And our overarching initial submission is that that realism is absent from SAA's case. Now, to take some examples from the exchanges between the court and Mr. Gill yesterday, my Lord the Master of the Rolls asked what the data protection issues add to this case. And we say with respect that that is a good question to which there is no good answer. Most fundamentally, if the Secretary of State is wrong about Rwanda being a safe country, then data protection adds nothing. Conversely, if the Secretary of State is right and Rwanda is otherwise safe, is it really being said that data protection issues are capable of overturning the conclusion? We say no. SAA says yes. He submits that country safety requires not only compliance with Article 3, but with Article 8 also. And let's be clear, by Article 8 compliance, he means having a fully compliant, that is UK GDPR or EU GDPR compliant, data protection regime in law and in practice in that country. And we say that is plainly wrong. At the very least, it's an attempt to break remarkable new ground. My Lord the Vice President asked Mr. Gill if he knew of any Strasbourg authority in support of his proposition. Answer, no. We say SAA's submission about country safety requiring Article 8 compliance lacks foundation either in legislation or in case law. But more than that, SAA's submission has alarming and frankly untenable consequences in terms of public policy and practice. And here I respectfully pick up on my Lord the Lord Chief Justice's observation about the logical implication of SAA's case, which I can paraphrase this way. The UK may never lawfully remove a person from this country to any other country that does not have, in law and practice, a data protection regime that is equivalent to that in the EU/UK. Now, Mr. Gill sought to evade that outcome by referring, for example, to the prospect of asylum claimants consenting to the sending of their data back to or to their destination country. That answer won't wash for a number of reasons. The most obvious one being that an applicant who withholds his consent thereby blocks his removal to another country that does not have a demonstrably GDPR compliant data protection environment. Now that is obviously untenable, but it is the logical conclusion of SAA's case. And my submission about this unrealistic overreach in SAA's data protection ground is brought home if one considers what data we are actually looking at in this case and the safeguards attending the transfer of that data to Rwanda. Now, to short circuit, as outlined in paragraph 99 of our skeleton arguments, at stage 1, the data transferred is name, date of birth, sex, nationality, date of making an asylum claim in the UK, and photograph. That's it. Basic identifying information. You can see stage 1 playing out in practice in SAA's case. For your notes, SAA volume 18, tab 58, page 2594, is the Home Office's email to Rwanda affecting that stage 1 transfer. Then at stage 2, see our skeleton at paragraph 99.2, the data that is transferred is that which is required to give effect to the safe reception and accommodation of a removed person in Rwanda. What this shows is that the data transfers we're looking at in this case are confined to what is necessary for the MEDP to operate. They merely give effect to decisions and arrangements relating to the removal of the person. Now, if you propose to remove a person to Rwanda, you can't do that without, in some trite sense, processing a certain amount, sharing a certain amount of data about that person with Rwanda. But that is not the same as that being a condition precedent for the lawful exercise of powers under the immigration rules. As to safeguards, the package of measures the Secretary of State relies on comprise the MOU that you've looked at. And for your note, it's Annex A in particular that contains detailed provision on data protection measures. The data sharing note verbal, Rwanda's own data protection legislation that closely mirrors the contents of the UK's GDPR. And finally, the additional specific protections that were sought and provided concerning data safeguarding measures that the Rwandan authorities have undertaken to apply. For your note, references to those additional assurances come in SAA Volume 17, Tab 48, page 1272, on a number of specific assurances, and 1276 that expressly confirms that where removal of an individual does not go ahead following a stage 1 transfer, any data about that individual will be disposed of. So in data protection terms, this case is about the transfer of a very limited set of personal data to a single recipient, namely a foreign state with whom the UK is working in partnership. And that is undertaken subject to explicit and precise safeguards on the use of that data. In those circumstances, I submit that the Divisional Court did not err in what it called its logically prior conclusion, namely that the data protection issues SAA raises are incapable of rendering these public law decisions under the immigration rules unlawful, such that they should be quashed. The Divisional Court took the right approach, and I say that it reached the right conclusion on that point also. That is for the reasons it gave, which in essence were that nothing in the rules themselves indicates that they are conditional on prior compliance with the data protection duties on which SAA relies. And also because of the submissions I've just made about the fundamental lack of realism in SAA's case. And further because of the points specific to each of the 3 data protection issues that SAA relies upon. Those points are summarised in paragraph 106 of our skeleton. And I'll pick those up with very brief observations on each of those 3 data protection issues in turn. The first is the Chapter 5 issue. The argument there is that these transfers of personal data to Rwanda are unlawful because they contravene Article 44 of the UK GDPR. You'll find Article 44 in Core Authorities Volume 1, Tab 11, page 184. SAA says that the Secretary of State cannot rely on Article 49(1)(d) as the basis for lawful transfers because, SAA says, she was required, A, to have these transfers approved by Parliament, and B, check whether Rwanda's data protection laws were up to UK/EU GDPR standards. We say with respect, those arguments are hopeless for these reasons. The first point is that if your lordships have an opportunity to consider Chapter 5, that is Articles 44 through to 49, it is abundantly clear that there is no hierarchy within that chapter. In other words, there is no requirement that Article 49(1) can only be relied upon where the preceding lawful transfer options fail. The second point is that it is very clear from the statutory language that there is no requirement for any legislation or any involvement of Parliament at all, either for in the shape of some sort of adequacy regulation that would say Rwanda is a safe country for all data transfer purposes, or for the purposes of expressly acknowledging, putting on the statute books, a reference to data transfers to Rwanda being for reasons of important public interest. Third reason why SAA's case is wrong is that these very limited data transfers I've outlined to you are plainly necessary for the important reason of public interest on which we rely, namely the maintenance of effective immigration controls. You have my submission that the data we transfer goes no further than and is essential for the fulfillment of that purpose through this particular means by the MEDP. Final point as to why SAA's case on the Chapter 5 issue is wrong concerns his focus on the adequacy of safeguards. And you'll recall, both from Mr. Gill's submissions and from his written argument, that he places particular emphasis on what he says was the exercise required here. Full scrutiny of everything about the Rwandan practical and legal environment, ranging from its overall legal system through to data protection specific concerns. Now, the reason that's wrong is that the considerations on which he relies are expressly laid down in Article 45, as you'll see if you get a chance to turn that up. That is a provision providing for adequacy decisions. An adequacy decision is where a measure is implemented, effectively recognizing the destination country as safe for all transfers of all data on an unrestricted basis. No surprise that Article 45(2) is stringent as to the exercise that must be undertaken to satisfy oneself if that is the measure that's going to be adopted. But that's not what applies to Article 49. And the same answer applies to Mr. Gill's reliance on the Schrems litigation. That too was a case which saw the CJEU strike down the so-called Privacy Shield data sharing decision. But that was for exactly the reason I've just touched on. That was an Article 45 decision, not an Article 49 case. So Mr. Gill seeks to apply the wrong standard in terms of data safeguards. For that reason also, this case on the Chapter 5 issue goes nowhere.
Could you just remind me where we find that decision in the bundle? I know Mr. Gill gave it to us, but
I'll refer you most relevantly to the second of the two Schrems decisions.
Yes.
That is at Core Authorities, Volume 4, tab 74. The decision starts at page 3232. And for your note, at paragraph 199 of the court's judgment, it makes clear that this is an Article 45 analysis that's being undertaken. That's on internal page 3363.
so if that's core bundle 4, did you say?
Core Authorities, Volume 4.
So that's bundle 22, I think, for our purposes, is if somebody could nod at me if I'm right.
22.
22, yeah.
And it's tab 74 within that volume.
Thank you.
So for all those reasons, Mr. Gill applies the wrong standard to his safeguard needs. The second of his data protection issues concerns data protection impact assessments. Now, we could readily go through an exercise of looking up the final DPIA. For your note, that is at volume 17, tab 47, page 1206. But the operative section begins at page 1213. I say that if one scrutinises that decision against the Article 35 conditions, see in particular Article 35(7), if one applies the approach mandated by the Divisional Court in the Bridges case, which we cite in our skeleton argument, the crux of that judgment for present purposes being that where conscientious assessment has been brought to bear, any attempt by a court to second guess the data protection impact assessment will overstep the mark. Alongside Mr. McGinley's evidence about the DPIA process, but we really don't need to undertake any exercise like that. As we say at paragraph 106(1) of our skeleton argument, sometimes a DPIA is how you get to substantive compliance, but sometimes it can simply be a checking of compliance arrangements that are already in place, and we are in the latter category. So if you are with me on the transfers issue, then the DPIA issue is incapable of adding anything. The third and final data protection issue SAA relies on is the Article 13 notification issue. Now, Article 13 prescribes information that must be provided to individuals. The concern here is not that there was a shortfall in any of the prescribed information. Criticisms are made by the Divisional Court of language availability and internet availability, which your lordships would have seen. Mr. Gill also criticises the chronology. He says, well, some of the information only arrived with SAA at the time or shortly after the stage 1 data transfer. But even with those criticisms in mind, I say that this Article 13 point is incapable of founding the substantive relief SAA seeks. And that's for three reasons. One is that the UK GDPR does not prescribe any particular notice periods that must be provided in order to give individuals an opportunity to make representations about what's going to be done with their data. So a point about inadequate notice, I say, is in principle available at common law, and you'll have seen that SAA adopts asylum aids points to which we've responded. But under the GDPR, at this point, that's nothing. Secondly, to the extent that the criticisms of the Secretary of State's Article 13 notices are well founded, they are in any event historic. You'll have seen from our respondents' statement that we are taking steps to remedy any deficiencies in language and internet provision. And plainly, SAA and all other claimants now have all of the information to which they're entitled to help them understand what will happen to their data in the context of the MEDP. And finally, we say it's fanciful to suggest that any temporary Article 13 contravention caused any material prejudice in this case. Recall again the very limited nature of the data transfers and the safeguards, including the safeguard that if removal does not go ahead, the data will be deleted. So it's, we say, an effectively inconsequential contravention that has been put right and doesn't take a common law complaint about notice anywhere. For all those reasons, the Secretary of State invites you to refuse permission or otherwise to dismiss this ground.
Can I ask you a brief question, if I may, Mr. Hopkins? My understanding of Mr. Gill's argument was that the data protection issues were intimately interrelated with the question of the safety of Rwanda. And I think he went so far as to say that we could not fairly decide the safety of Rwanda without considering the impact of data protection on an appellant. And what do you say about that?
I say, and I hope I've made this, I've covered this point to some extent in my submissions, that that is fanciful. It's without any warrant in the data protection legislative regime, which provides no basis for a conclusion that contraventions of that scheme undercut any public.
Well, let me just explain the way I understood it. I think just saying it's fanciful may not be quite not all one could say. I think what's said is this provides a danger to an appellant, a specific danger of the data getting into the wrong hands in an environment as described by UNHCR, and that the data itself exposes the appellant to risk if the appellant is one of the ones whose asylum application is refused, and that is integrated into the other aspects of danger, and therefore one should, I think he would say, give permission to appeal and hear the whole thing either separately or together, as all part of the same process. Now, obviously, procedurally, that's a nightmare for the court and for everybody else. But I just wanted to hear your specific answer to that.
Well, my lord, the first point is, as I say, there is nothing in the legislative scheme that points to this issue about data protection compliance even being a relevant consideration when it comes to assessing safety. So
Well, except you've got assurances in the MOU, as you told us.
correct, but one shouldn't conclude from that the data issue is integral to the safety issue. I hope I was clear that what we are not doing, the Secretary of State's part, is saying, well, it doesn't matter whether or not you comply with your data protection obligations. Of course, the Secretary of State is concerned to ensure compliance with those obligations. But what I do say is that this is not the kind of issue, the kind of public law decision on which any that is vulnerable to being overturned by any data protection contraventions. Mr. Gill relies on, or makes reference to the El Ghazouli case, where the public law decision under challenge was to provide mutual assistance to the United States, but that decision comprised entirely of the provision of information relating to policing matters. That's in complete contrast to a case like this, where, as I submit, data is merely, in a trite sense, an obvious ancillary and accompaniment to the substantive decisions under the immigration rules.
Well, thank you, Mr. Hawkins. We're a couple of minutes late in carrying on. Mr. Hussain, I think we're with you now, aren't we?
My lords, yes.
And I'm afraid I have to emphasise that we must rise at 4:15.
My lord, yes. My lords, may I first address you on the issue of certification? And I have 4 points. We respectfully take issue with Sir James on the question of the substance of the test as regards what happens in the High Court, the Divisional Court. We agree with him that the test is a high one. The case has got to be bound to fail. We agree with him that it's rationality review, but what was missed with respect to Sir James's submission is that the recognition at the highest level that the range of responses to that question of whether the case is bound to fail is so narrow that the court, in substance, has to ask the question for itself. And can I please direct you to paragraphs 24 to 43. Sorry, 24 and 43, and also 46 of our skeleton, where we set out the authorities in very brief detail, and just give you the relevant extracts from them. And finally, we don't accept Sir James's submission that at the level of this court, the review is remoter still, because we submit that mere disagreement would suffice, in the same way that if you disagree with the Divisional Court that the policy was ultra vires, that would be enough. And that's because it's a question of law. So if your lordships think that the case is not bound to fail, that would suffice to give you grounds to allow the appeal, and on the basis that the court's conclusion at 179 isn't sustainable. That's the first point I wanted to make. The second point, there was a suggestion that we didn't put this in our ground. The grounds in terms don't address it, but the ground spoke to a skeleton before the Divisional Court, the Vice President, and before this court, and on each occasion there were references to the certification decision. What we did is we grouped the grounds by reference to the area, and then in the skeleton at every single stage, we expressly addressed certification as well as the substantive decision. That's the second one. And in the skeleton before you, you've got that at 24, 43, and 46. The third point I wanted to make is that the Divisional Court refused our application to cross-examine 4 witnesses from the Secretary of State. It refused admission of country expert evidence. All you get is 179. I've already taken you to paragraph 285. And the last point I wanted to make very briefly is NA Sudan, one of my less successful outings before my Lord Vice President. Your Lordship, the paragraph you had in mind, I think was 242. We gave you an email.
Yes,
and I just wanted to say, the last sentence in that paragraph, you said, my Lord, the scope for exercise of discretion is constrained because the applicable provisions oblige the Secretary of State to certify unless satisfied the claim isn't clearly unfounded. That constraint doesn't arise
Yes, I saw that.
here, and there is case law about whether in substance it makes any difference anyway. So those are the 4 points I wanted to make. Can I just indicate that if you want more help on this, then I'm very grateful to my learned friend Miss Knight. She's going to be able to give it to you. I don't want to take you through to yoga class, ZT, to house.
I don't want to detain you, but
No.
as this issue has emerged or bubbled more to the top today, it's really I'm a bit perplexed about why this wasn't taken as the issue and decided, because if it's good, then hasn't the Divisional Court and to an extent us been wasting our time and the valuable time of 46 counsel?
Submissions were made that, as Sir James said, that you should stop at clearly unfounded. The court said no, we're seized with the bigger picture. The reason for that was the chronology. The chronology was you had inadmissibility decisions as of, I think, the 8th, the 6th of June, whenever it was. We were in court, 7th of June, we were in court on Wednesday the 8th. Interim relief on the 10th of June. The flight was on the 14th. So it was a chronology. We didn't have the opportunity to make the application, the human rights claim, the certification was responsive to the claim. It's a chronological answer that I can give you. But I absolutely see the force of your observation, my Lord, if I may say so. Parliament, and it's not just case management, it's Parliament clearly intended questions of the merits to go to the specialist body with the ability to hear cross-examination and admit expert evidence. They didn't do that.
Did you say that to the Divisional Court?
Yes, we did.
The Divisional Court didn't even record the submission.
They recorded at 183, but there are our application for cross-examination. You don't have the application, but you've got the refusal of it, I think, Mr. Justice Swift's order. Yeah. I think in Miss Nake's case, you've got...
What's the reference for the refusal?
For the?
Refusal of...
Perhaps somebody can give it to us in a minute. Because I know you've got a little bit of ground to cover, Mr.
And there are other orders.
Yes.
And there are other orders refusing the admission of expert evidence. So it was odd, as I said, driven by the chronology. We had inadmissibility decisions, but we didn't have human rights decisions at the time, and we didn't have certifications. There was nothing to challenge to stop the removal.
So the proceedings got going first.
The proceedings got going first, and we had amendments and re-amendments, which did absolutely challenge certification. Absolutely.
It was dealt with in 183.
Yes. The argument that you should look at certification and stop there was dealt with at 183. All you get by way of decision on certification is parenthesis in 179. You've got that point, which does not take into account, your Lordships will have observed, the advantages obvious advantages that flow from before the tribunal, cross-examination, etc. Now, that is, of course, relevant to disposal if you find there's an error of law. I'll come back to disposal if I may. The only other reference I wanted to give you on certification was 285. I've already taken you to it. It's where they say we've quashed the decisions, but our general conclusions will no doubt inform the Secretary of State's further decision-making on certification as well. That's 285. I took you to it before. Secretary of State will have to consider the human rights claim and the question of certification in the light of all the relevant material, including, if appropriate, our conclusions on the UNHCR evidence. I better get on to ground 1 and Ilias. The first point I wanted to make is a point of principle. And that is that Ilias is a process duty, and that's the reason we started with it, and it's the reason why I wish to begin my reply on this topic. And it's clear, Ilias is process, see Ilias 162 to 164, procedural obligation breach, 164, that's sufficient to allow on Article 3 grounds. 137, even if you've got nothing in your claim, there can be a procedural obligation breach. That's really important, because if you go immediately to serving an assurance as tellingly, with respect, my learned friend did, without a thorough examination, you are liable to go wrong. You won't have the information. In the Jordanian context, Ottman, if you haven't worked out that the Jordanians think that electric shocks aren't torture, the assurance not to torture isn't going to be worth very much. Or if there's a rogue body which you haven't spotted exists, operating outside the law, the assurances need to address what that body does and how it may be controlled. Not appropriate to just ignore it, for obvious reasons. Ilias also has the virtue of occupying a middle ground. In my Lord the Master Roll's summary of our respective positions, it might be said that we say all of this is terrible by the real risk standard, on the real risk standard. It may be said that Secretary of State adopts what might be described as a Panglossian attitude. Ilias occupies the middle ground because the issue is, have you got enough to put you on inquiry, to examine? And we say there was abundant material that the Secretary ought to have got to put her on inquiry and to pause and investigate. She didn't do that. Now, the first question then is, under Ilias, did the Secretary of State discharge this duty? Central to Sir James's claim that she did is that the MOU and NV responded to concerns, including those of the UNHCR. We immediately ask the rhetorical question, how can Sir James accept that, but then say the past is of only peripheral relevance? If that's not inconsistent, it's in tension with his broad submission that it's Brave New World, the past is a foreign country. It amounts to saying that those concerns, including those of the UNHCR, were of peripheral relevance. And that, we say, that submission only needs to be stated to see its untenability. But did the Secretary of State, did the MOU NV respond to the concerns, the UNHCR's concerns? You've got the conceptual point. There's a colossal tension between Sir James's big point, which is ignore everything else, just look at the MOU and NV, they can do all the work, and his claim made right at the end of his submissions that, no, we discharged Ilias because the MOU and NV responded to the concerns. That's in evidence, it's in Mr. Armstrong's statement, and Sir James said that about 3 times. Very, very important, if not more. Very important to his submission, because it's of obvious concern what the existing system is. So, was the MOU and NV responsive? Now, my learned friend Mr. McCulloch showed you 2 documents where the expertise of the UNHCR was recognised. The value of their assessment of Rwandan processes was recognised. The lack of any other body capable of verifying Rwandan processes was recognised. But, for whatever reason, not for us to speculate, ministerial clearance wasn't granted. But there was a suggestion that the UNHCR might be critical. So, there was an interview. There was an interview with the UNHCR on the 21st of March 2022. But that interview was, so to speak, blind. UNHCR did not know what was in prospect. We have that very clearly from Botnik 2, paras 131 to 133, page 1722. That interview...
Which paragraphs?
131 to 133. So that's Botnik 2, 5, tab 96, page 1722. Now, that interview has to do a lot of work for the Secretary of State, because if the MOU responds to the UNHCR's concerns, that's all you've got. The point I made about the timeline, I said in my opening, this point simply was not available to Sir James on the timeline, on the evidence. That's all he's got. So the first point is the information that's given there isn't even properly recorded. That's Mr. Botnik, paragraph 36 in that same statement. But the deeper question is what was missed? If you'd properly engaged the UNHCR, what would you have got that you did not get because you've approached them blind? And what you would have got that you missed was the role of the DGIE. It's this rogue body that operates outside Rwandan law, that makes decisions based upon security concerns, international relations, and unpalatability. It's the first thing you would have got. And your assurances might just have addressed that. The second thing that you would have got is the Rwandan understanding of refoulement. So your note verbal and memorandum of understanding might just have said, this is what refoulement means, to make it crystal clear. Torture includes electric shocks. You would have got the history of refoulement from the UNHCR, mass abuse, as it is described in this court, under a previous transfer arrangement. You would have got information about a cross-border transfer, to Tanzania. Those are the 34 individuals, and to Uganda under Israel. You would have got that material. But the past, of course, we are told, is of peripheral relevance. An ambitious case. It's an even more ambitious case when we see what the IAGCI reviewer says. I've taken you to, or referred you to, the paucity of the interviews that were relied upon. This is a report commissioned as part of a statutory process. It is a serious document to use.
IGE?
IAGCI. The document is at Bundle 4 Common, tab 80. The relevant passages are 1449 to 50.
I'm so sorry,
1449 to 50. I'll just tell you what they say.
Common bundle.
Common bundle, yes. And that highlights that it would have been useful to have information about the DGIE, the position of the eligibility officer, confidentiality, recognition rates, appeal rates, reasons. I'll come back to reasons, because Sir James's submissions on reasons were very telling. It was a basic error that he made about the reasons. That wasn't the old world, it's the new world, those reasons, the reasons document.
Are you making the point now or coming?
No, I'll come to it. The usual vice, I'm sorry. Appeal rates, reasons, appeals, and processes. That's what the reviewer says it would have been helpful to have. So it is, with respect, absolutely hopeless to suggest, and forgive me if I'm not moderating my submission, but it is really a submission your lordship should reject. The idea that the MOU and note verbal responded to concerns, including those of the UNHCR. How possibly could they? And then the next question is, well, do the assessment respond to the views of the UNHCR? Well, they don't do any work as regards the assurances. The assessment simply set out what the Secretary of State thinks the general position is. That's really our Tameside ground. Our Tameside ground is that there are two operative decisions, one set in our individual cases, and the other operative decisions is the published decision. The public face of the Secretary of State's assessment of Rwanda is that assessment. So does the assessment do the work? But they too, we say, are Ilias deficient for all the above reasons. By that time, you do have the 25th of April interview. You've got that. But it's very obvious if you look at the assessment, and indeed it's common ground between the parties, that the central concern in that interview, namely 3 recent instances of refoulement in the face of UNHCR's request to desist, simply aren't fed into the assessments. And you have that from Mr. Stairs. I'll give you the reference. He accepts it in terms. So it doesn't matter, but he accepts it that wasn't fed in. Well, the idea that this doesn't matter, 3 more instances of refoulement, and your document is saying this country respects refoulement, that doesn't matter. It is said. Mr. Stairs, and that is volume 3, common 3, tab 28, page 1065, at paragraph 25. And that really was enough. That's all I'm going to say about Tameside. But obviously, there's a crossover between Tameside and Ilias. The Ilias duty, I'd remind my lords, para 141, is proactively to seek out and assess, obviously, relevant information. Not only did the Secretary of State not discharge that duty, it might be said that she sought to thwart it by not engaging properly with the UNHCR lest they criticise it. So that's the Secretary of State. What about the hearing? Because the court said that the information available has expanded during the hearing. That's paragraph 46 in the Divisional Court. So did the exchange between the UNHCR and Rwanda and the Rwandan government meet the Ilias duty? We respectfully say no, because the duty, it's not that it's not a tick box duty, Mr. James's word, the phrase I used was that it's not a post box duty. You don't just act as a post box, putting UNHCR's concerns to the government and just exhibiting their responses without critically making an assessment or evaluating them. The reason for the duty is to avert the risk of ill treatment. That is the very serious context. And where does one see the assessment of the Rwandan government's responses? Even today, we don't know whether the Secretary of State supports the Rwandan understanding of refoulement or the legality of the DGI decision-making on the basis of unpalatability, etc. We still don't know what she thinks of it. There's been no assessment of that. What about the Divisional Court, my lords? Can it be said that the Divisional Court, they had more evidence, as we've noted, still nothing on Israel?
Well, Mr. Hussain, this is a reply. You're supposed to be responding to Sir James's submissions, and this, I don't think Sir James has submitted that there was anything on Israel before the Div Court.
No.
So
That's a tangential comment. Sorry, I'll move on.
Particularly as time is short, this is not an opportunity to restate the case
I'm not. Sorry.
In broad and loud terms.
Yeah.
It is to respond to specific submissions.
Indeed, it's my lord, indeed. But he makes the claim that the Divisional Court discharged the duty, right? At the end of his submissions,
Yes.
in very brief outline, very briefly, for forensic reasons, that's understandable. That he does it briefly, right at the end of his submissions. We say the logical place is at the beginning of the analysis. You've heard the submission already, that you can't, if you skip, it's like saying the answer to the Tameside complaint is, my decision isn't substantively perverse. You've got to go through the process. The process supports the substantive outcome. But we have nothing in the Divisional Court about whether the current Rwandan process is adequate, about the Rwandan understanding of refoulement. We've got nothing in the Divisional Court about whether refoulement is occurring in the current system, at the airport, in country, cross-border. We've got nothing in the Divisional Court about whether or not the DGI engage in so-called off-the-books decision-making. Nothing about large-scale abuses. Nothing about whether or not the judiciary is captured.
But I think my Lord's point to you just now was that Sir James's answer to all those submissions, which you made in opening, was that it was a sufficient answer to say that this was a new arrangement, that assurances had been given, and that there was no reason to suppose that the problems of the past would be repeated. Now, what we want from your reply is your answer to that submission. I mean, I've summarised it, Sir James will probably crucify me for saying it like that in such short terms, but that's what he said. And just to say, well, there were all these problems, we've got that, that was how you opened your case.
Yes.
And to say the Divisional Court didn't mention them, that's how you opened your case. So I'm just really reiterating what my Lord, the Lord Chief Justice, put to you, because we're not going to be assisted by...
No, I'm very grateful to have that. Can I then just address the areas on which you still don't have any answers as to Ilias, made by Sir James? So independence of the judiciary is the first one I was going to go to. He said that there's no, that's a nuanced finding. Your Lordship, the Lord Chief, observed that this wouldn't normally be enough for a country guidance or general finding that the judiciary was not independent. The point that we make under the Ilias ground, and can I stress that neither in my opening nor now am I going to the underlying material because I want a rehearing. We sought to respect the appellate function and the restriction of in the role of this court by explaining that these were matters in which there were, with respect to which there were evidential gaps that needed thorough examination. We followed our grounds quite carefully, or tried to. As regards the judiciary, Sir James repeatedly made the point that the UNHCR had not criticised the independence of the Rwandan judiciary. The answer to that is no inferences should be drawn from that failure. If you look at Mr. Botnick 2, paragraphs 5 to 6, and that's pages 1676 to 77, tabs 96, he says that we've got to operate diplomatically with countries, don't infer anything from the fact that we're silent about a matter. He says that in terms, so no proper inferences to be drawn. The key point about the Divisional Court's finding in the extradition case, and this is Ryu, is that whether or not it was sufficient to trigger an inquiry. For the Ilias ground, that's all that we need. In any event, we say that the findings weren't nuanced. At paragraph 149, you had a very clear.
This is in the big judgment.
In the 500 plus paragraph judgment, 149, the evidence was accepted that the judges are loyal to the party. They have to. Their primary loyalty is to the party. And the only issue about whether or not the very high flagrancy standard was met was whether or not you had virile defence representation. We know from the evidence about lawyers that that doesn't exist here. We also know that the Rwandans have a vested interest, and yet
In what?
In presenting, we would say, the MOU as working. They have that's a Secretary of State's case.
Yes. Well, that's right. That's one of the ironies of this. That if the Rwandans, it said, will want to ensure that that the MOU looks as though it's working.
Yes.
And so if the judiciary become involved and don't operate independently, then it won't be working. And so the Rwandan government will want them to operate independently. I mean, one can go round and round in
but
circles.
how do you see? How does one see?
I take the point, but I did want to know what exactly you meant by.
Yeah. It's an odd submission to suggest that independence can work in our favour.
No,
Arbitrariness of decision making can work in our favour.
I don't think St James made that submission.
No. And obviously, your lordships have the point that the issue is real risk.
Yeah.
And
real risk of refoulement at the end of the process.
Yes. Yes, and also denial of refugee convention rights.
Yes,
as well. But essentially,
but
yes,
that then leads to refoulement.
Yes, it is. And the point, the only other point I was going to make is that the Secretary of State's witnesses do not address this at all. You've got neither Armstrong 1 nor Mr. Mustard address this.
This is judicial independence.
Judicial independence, yeah. Mr. Armstrong, paragraph 19, page 1014, tab 26, and Mr. Mustard is paragraph 13. I've lost the reference. I think you've had it before.
Yep.
So, you're giving us references for statements that don't deal with the point.
To show you that they don't deal with it.
You've got limited time.
Yeah, no, but they say things like the Rwandan constitution provides for the independence judiciary. They just ignore it.
Yes.
They assert independence without addressing it. Mr. Armstrong said Rwanda is a safe country with respect to the rule of law. The DGIE on off the books record keeping. So Sir James said, well, look, the registration system will avert risks from the DGIE. He wasn't sure. This is another Ilias ground for present purposes. He said he wasn't sure whether or not it sat on the RSDC. My Lord, the Vice President's recollection was correct. They do sit on it, and the Secretary's own witnesses say that. And that's Mr. Williams' paragraph 35, volume 3, tab 29, 1077. Director of DGI advised that members of the RSD included officials from ministries of departments.
Yes.
And again,
forgive me. We were shown a table yesterday or the day
yes,
before,
you were,
with the people, with the representatives who sat on it.
Yes.
And there was the DGIE directly didn't sit on it, if I remember the table.
It was the umbrella organisation.
But the organisation of which it is part,
yes.
A bigger ministry, has a representative.
Except that Mr. Williams, in terms, accepts that the DGIE sit on it.
Well, what you read out didn't say that, but maybe you didn't read your life.
I probably didn't read it. Members of the RSD included officials from ministries of department, for example, the DGIE.
Okay.
And that's volume 3, tab 29, 1077. Did I not read that out? Sorry. It's 35 of Williams. And that's also Mr. Botnick's evidence as well.
Okay.
At page 1693.
So what that means is that the representative of the bigger organisation is
the DGIE, exactly. That was something Sir James wasn't clear about. The evidence is clear about it. And again, if you'd investigated it, you'd address that. If you'd investigated it, the MOU and the NV would not have provided, may not have provided, for the DGI representative to sit on the joint committee, to be in charge of record keeping, and to be in charge of complaints. And that's UNHCR's note from Tuesday, 6 Roman 4. Can I just address you on reasons and processing in batches? My Lord the Vice President asked Sir James that question. He said that he didn't know what the position was. As far as reasons are concerned, this is important because the reasons you were taken to date from July last year, 3 months after the MOU. Yes. So that's the Brave New World. It's not a one-off. Botnik 2 shows it's a batch of about 88 reasons. It's a sample of 88, one of 88. That's Botnik 2, paragraph 61.
Yes, but these don't relate to people returned under the MOU.
No, it doesn't. I'm just making a chronological point. It's the point you made, my lord, about a culture. And you would have... The point is this is the same organ. It's the same institution that's going to be deciding the cases. I entirely accept it's not under the MADP, but we wouldn't expect magically the reasoning to improve. Or if it turns on training.
Your point, Mr. Hussain, is really this, that the MOU was 3 months before these decisions. Yes. And if the body is equipped to give reasoned decisions, even short reasons, which obviously are to be encouraged generally, one might have seen it by July. I mean, that's your point.
That's my point, and it feeds into the issues of culture that my lord was reverting to yesterday, and training as well. Sir James's position on training was not sure we have final resolution on that or where that lands. All these things take time to bed down. Well, quite. It's our submission. It was wrong for Sir James to say that other matters, such as confidentiality, have fallen away. It's in our skeleton. UNHCR also made the point in their observations below and adopted those. It's in our skeleton at paragraph 11. That absolutely hasn't fallen away. And the position on lawyers is concerning in the sense that there's always been an issue about access to the hearing as against representation, and also the numbers involved. And we've got some material on that, which I can just address you on in a moment. That's all I wanted to say on Ilias, but you'll appreciate, my lords, that forms a very important platform for the submissions I make on Suring and Ottman. So Suring, ground 3, 4 points I wanted to make, if I may. My lord, the Master Rolls was absolutely right to say that the test is substantial grounds for a real risk. The first point, we say they didn't ask the question for themselves. There was no engagement by Sir James.
Sorry, the first point was substantial grounds for real risk.
That's the overarching question. But I just wanted to make 4 points.
I'm just noting down your 4.
Four legal points.
What are they?
One, that the court didn't ask the right question.
Oh, I see.
Yeah. And Sir James didn't address you on paragraph 71. We've got all of those references to entitled to conclude, entitled to rely. What you don't have is an engagement with paragraph 71, where the court says that the UNHCR don't undermine the Secretary of State's opinion to the extent that it can be said to be legally flawed.
Your point on this is that paragraph 71 says the reasons we've already given, the Home Secretary did not act unlawfully when reaching the conclusion that the assurances could be relied on. That being so, the conclusion that for the purposes of the criteria in the rules, Rwanda as a safeguard country was neither irrational nor a breach of Article 3 in the sense explained in Ilias. That's your point? That's not the answering the Suring question.
No, 71, sorry, what I was looking at is about 7 or 8 lines from the end. The opinion of the UNHCR now expressed on instructions from Mr. Botnik carries no overriding weight. We must consider it together with all the evidence before us, decide whether it's that clause. Yes.
And one can trade gobbets, and we're going to have to look very closely at the totality of what the Divisional Court said, including its recital earlier of extensive passages from Ilias. But I mean, I think Sir James's point was that neither irrational, okay, that's a public law concept, but then nor a breach of Article 3 of the ECHR in the sense explained in Ilias.
Yes, yes.
So we have to make of that what we can in the light of the preceding 70 paragraphs.
Indeed, and the preceding 5 lines.
Oh, indeed.
That clause
Yeah,
in the 5
yes.
lines, which is, you've got all the entitled to formulation. Your lordships put the point about wouldn't it be better to say it right, but then you've got references to legal errors. The second point I wanted to make, I'm not going to address you on the permission to appeal. I don't think there's anything in that. Second point, substantively, there's a very cursory analysis of the UNHCR's evidence. So 2 of the 15 areas. Thirdly, on the UNHCR's expertise, so James doesn't contest that. And then fourthly, on paragraph 73 to 77, risks, we stand by our skeleton.
Yes.
Ground for Ottman, so clean slate. Paragraph 7 is the UNHCR's material, the UNHCR's note.
I'm so sorry, paragraph 7 of what?
Of the note that you've got, the references note, the clean slate note. That's a convenient place to take the governing legal principles and the legal authorities.
Yes. Did Sir James disagree with those? Let me just remind myself.
Well, he must be disagreeing with them because he says that you can ignore
forgive me, I haven't got it, I can't memorise every bit, and I'm now looking for it. I know it's here. Yes.
So it's contrary to principle to ignore the past, and contrary to the authorities, which are set out in 7A. Fifthly, so James said, the second point I was going to make on Ottman is that Sir James said that UNHCR's position was that Rwanda can't be trusted, insofar as that seeks to draw the issue onto better forensic ground for him. It's got to be resisted because Mr. McCulloch, I'll remind you, said in terms that they weren't going anywhere near the issue of good faith. Their conclusions did not assume or impugn, they did not impugn good faith. No. So it's squarely area in their expertise. The 15 areas that my lords are aware of actually are supported by XCOMs or handbook extracts. So these are objective standards which they've laid down. It's not good, they're not good ideas. These are standards. They're objective standards if you look at the 15 areas. And therefore we say that on the question of deliverability, my lord's observation about 1894 of Ottman, central government, local government, deliverability, you've got the expert body saying they're not deliverable. My Lord the Master of the Rolls raised the issue of 1879, the issue of cooperation with international bodies. Again, you've got the material. So James said that, I think, that they cooperate. That's controverted by and had responded to the material that the UNHCR had been put forward. We obviously ask you to look at the substance of that responding and also the history with UNCAT subcommittee on torture as well. As regards monitoring, Sir James said, well, the UNHCR could shout loudly and that would be the practical bulwark. That's not a proper response. We respectfully submit they're excluded from the process. You have that material. You also have our submissions on how the monitoring committee lacks teeth and can't deliver justice. That raises the issue of systems. Systems are relevant. There was an exchange between my Lord the Lord Chief and Sir James about systems. This is about systems. And I think my Lord the Vice President explained, well, no, the governing question is real risks. And we can respectfully concur. If you recall, the whole issue of the safety of systems arises from Luxembourg in the case called NS. And there's a discussion about whether you've got to show systemic error or whether it's sufficient to show a real risk in EM Eritrea. We are not in that territory at all. The Secretary can't get any comfort from the idea that there's a system in operation, nor can she get any comfort from the idea that what's involved is predictive. So James repeatedly says the issue is predictive. All SIRING cases are predictive because the idea is that an ex post facto remedy is not going to be sufficient. Incentives, we say the financial incentive, the evidence of financial incentives is exiguous in the extreme. You haven't got the financial note verbal disclosed, and the reason for that is because the Secretary of State explicitly said we're not relying on the detail. Friendly foreign state, see Book Daikai for what Lord Bridge said about that. Ordinarily, yes, if you've got reason to suspect them, no, even Lord Bingham in Yogothar's quotation, which is cited, says that Ottman, MSS, Ilias don't say anything like that. You've got to make the inquiry. The issue is so important.
Now, I think your time is up, Mr. Hussain, and if others will lose out if you have more to say now, although I would imagine that Mr. Drabble may not need his whole 20 minutes, although his face tells me that I may be too optimistic. But anyway, are we nearly there?
Can I have 1 minute?
I'm sure Mr. Drabble won't mind.
So, Lord Panic on Article 31, 7 very short points.
In 1 minute.
Very short points. Hathaway.
Okay.
Literally, one
Yes.
sentence without subordinate clauses, Mother.
Excellent.
So Hathaway
Yes.
approves BO 10 at page 3719. 2, BO 10 is inconsistent with the proposition that removal can never be a penalty. Because clearly what was engaged was removal. Thirdly, you can't sort of externalise what would otherwise be a penalty. That would undermine the effect utile of this protective provision. Mr. Bizinski's point on Tuesday. 4, we're not implying language into Article 31. We're trying to discover what penalty means. 5, the test is workable. Is there a detriment? 6, it's got to be objective, not subjective. 7, when you're looking at whether the penalty is on account of, motive is irrelevant. And that's the true answer to Dublin. And forgive me for my answers on Monday, that's the true answer. Particularly in exchanges with my Lord Chief Justice, Vice President. I wasn't as helpful as I could have been. And then the last area, Schedule 3, just 4 short points. 1, yes, we agree, language, look at the language. Part 5, the focus is on the person. Everywhere else, it's a person. Second point, the key issue is that, of course, while you can, of course, have regard to generic material, it's the drawing of the generic conclusion that's objectionable, because the third point, it gives rise to a presumption. And the fourth point, that presumption is functionally equivalent to the statutory presumption as regards human rights. We accept it's not the same as the conclusive presumption as regards the Refugee Convention, but as we cite in our skeleton, Chahal says Article 3 is broader. Forgive me for trespassing on others' time.
Well, I'm sure they will. Mr. Drabble.
My Lords, we have prepared 3 notes, largely with an eye on avoiding the need for your Lordships to take a longhand record of the basic submission and to provide some references. I think they've gone electronically. I don't know whether they've come through. I have hard copies here in any event. I hand up 2 copies of notes. Yes, I have. I have them. Thank you very much. One of each.
Oops. You're giving me 2 of those. So we've got 2 notes.
Should be another one. I think I gave the ushers 3. There should be a document called RM against.
Long
I
title.
think you gave them to the usher in a form which made it easy for him to see which is which.
Yes, I think I
Okay.
already realised
So
that
I
I
think
wasn't facilitating that exercise.
Have a look and see what I've got.
One, RM
Yes.
against Secretary of State, appellant's reply, RM,
Yes, you've
propositions
done that
in
right.
reply, and
Thanks.
a note on long tracks.
Yes. All right.
We just call them 1, 2, and 3.
I don't mind what you call
No, I just thought it was helpful referring to it.
it, as long as it's
All right.
polite.
I think we need to make some progress now, Mr. Drabble.
Yes. So, if I go through the propositions, then the core of what I want to say now will be available to your Lordships,
Yes.
and I will then just take you to a limited amount of the material. If you have the document called Propositions in Reply, Propositions 1 and 2 are related to the personal circumstances and RM's own case, which is the subject of another of the notes. Some of that material I covered in a rather garbled way on Tuesday. The note provides full references. I will go to that very shortly, but propositions 3, 4, 5 and 6 are important, so can I just take those?
Yes.
Proposition 3 is the answer I have come to an exchange between the court and I think myself actually about what the position. No, it's not. It's an exchange between the court and Sir James about what the position was if the claim was refused wrongly by a defective Rwandan determination. Now, the basis of this submission is that the problem for the government, for Sir James, doesn't end with the proposition that there will be no refoulement. That is not an answer to the case, because you have to concentrate on what the position will be of the refugee or would-be asylum seeker whose claim is turned down as a consequence of defects in the Rwandan system. And my submission is that that position needs exploring, and the answer is that they will be in a very invidious position.
Can I just ask one question?
Yeah.
You're putting this in an Article 31 context, but the various sub-propositions might also be given an Article 3 or flavour, or simply be said to be a denial of the rights under the Convention.
Yes.
Or in itself.
Your Lordship will have gathered that in drawing up the original ASM skeleton, we were anxious to avoid having the old argument about the scope of the Convention
I see.
being based on Article 31. I have to say, for the purpose of getting a fairly sharp reply, I have put it in terms of penalty. But that doesn't mean I've abandoned it or don't even see as preferable the perspective in the original ASM skeleton. You put them both together. They walk together. And so the three sub-propositions are that you need to envisage at least three different circumstances. I've got about 6 minutes. One, as a result of the refusal, the refugee is exposed to an Article 3 risk. Two, as a result of the refusal, he is exposed to invidious living conditions with an uncertain legal status in Rwanda. Three, either of those is right, sorry, it's wrong. The simple exposure of the refugee to a defective claim system is itself a penalty. So that's the proposition about penalty. I will go very, very shortly to the academic material to try and stay within the time limit. We do go on to say, as an answer to the submissions Ms. Lord Panic made this morning, go to the academic material. We say there's a missing case in the analysis Lord Panic put forward. It's not enough to answer the case that we advance, to say that the signatories to the convention envisaged that you could expel without that being a penalty. As the commentaries say in the passage from Professor Hathaway, that is in a way integral part of Article 31. You need to have come directly to be able to avoid the penalty. But that's not what's happening here. What is happening here is that someone is physically present on the territory of the United Kingdom, would in the ordinary course of events go through their determination process, but is removed to Rwanda to be subject to the determination process in Rwanda, which is funded by, policed by, and subject to assurances and notes verbal by the UK government. This is indeed Laura Dubinsky's point of, again, I think, Tuesday morning. You can't offshore responsibilities to an asylum seeker who is on your territory and who's made a claim to you for asylum. And the commentaries do say nothing about those circumstances. And I would actually very strongly submit that it's obvious the signatories did not have that situation in mind when they signed up in the way that Professor Hathaway described. Proposition 4 is moving on to the next area of my submissions, which is ICSA. We put in the note on the long titles. We thought the most systematic way of demonstrating that long titles either deal with immigration alone, where the subject matter is what I would call immigration alone, or with immigration and asylum, where it's both. And so that material, as we say in Proposition 4, demonstrates that Parliament proceeds on the basis of a distinction between immigration and asylum. And once this is seen, the approach of the Secretary of State to ICSA is, we say, unsustainable. And then Proposition 5 is the answer to an exchange between, I think, between the court and myself, but obviously also relied on by Penny. We accept that it's conceptually possible for very clear wording to produce an effect not envisaged by the promoter of a bill, but that is not this case. Under the two competing constructions in a moment. All the material referred to in opening in connection with the promoter's intention is admissible as a aid to construction and demonstrate that the construction now advanced by the Secretary of State would frustrate the original intention of the promoter of the bill. The Home Secretary puts in the bill, it's accompanied by the explanatory notes. We know from the explanatory notes its intended scope. Does the construction advanced by Lord Panic fit with that? The answer is a resounding no. And I'll come to the detail of the construction in a moment. I referred in proposition 5 to a paragraph in our skeleton. And finally, the submission that none of this matters because getting rid of new obligations in relation to the Geneva Convention is unimportant and a natural consequence of Brexit. I just don't accept that. It's a subject that requires fairly careful consideration, as this case itself demonstrates. We spent 4 days arguing about what is an acceptable approach. And the idea that Parliament did it by a side wind because asylum is in some way unimportant and can be left to the immigration rules, not an obvious proposition. Maybe where you end up with after a parliamentary debate, but there's no sign of, well, it's obvious that that wasn't the intention behind the promotion of ICSA. So those are the propositions. On the face of it, I've got 3 or 4 minutes. If we go to the RM note,
Yes.
Which is related to propositions 1 and 2. Paragraph 1 records the RM's individual circumstances. They are not unusual, and certainly very many of the people who land on the beach in Kent will suffer from some, not all of these. They will speak a minority language, and they will have undergone a terrifying conclusion. They may well be extremely confused. So when we come at this, the court is thinking, as it plainly is thinking, of whether or not policy guidance can deal with the system. I just ask the court to bear RM in mind. When we actually look at what happened, that's paragraph 2, the timeline of RM's case shows the flaw in the Secretary of State's submissions on procedural fairness. In particular, much of the evidence was unavailable at the time of the decision on the 6th of June, and or if the Secretary of State had proceeded with removal on the 14th. No medical evidence was available within either the standard 7-day or extended 14-day period, and only preliminary medical reports were available before his planned removal. And the final bullet point is important. Secretary of State does not answer anywhere RM's crucial point that he did not have an adequate opportunity to make representations on why he had not obtained asylum in France on the occasion of initially being turned back from the UK on the 9th of May. In particular, the screening process was inadequate to elicit this information. And we've given the court all the references to that. I think I did manage to say on Tuesday that there was no possible contention that RM or his solicitors had been dilatory. They got on with it as best they could. And the result is the natural timetable for dealing with a case of this sort. And then we have then gone on to deal with a series of propositions advanced by the Secretary of State in the asylum aid appeal skeleton, saying that they just can't live with the actual facts of as demonstrated by RM. For example, that's the very first one. Every individual in the league claims, and every other individual served with an NOI, in fact had access to legal representation. And in fact, instructed solicitors. Comment, RM did not have representation at the time the NOI was served on him, did not get public funding until the final day of the initial 7-day period. And then halfway down the page, and I'll stop there, I do ask the court to bear all this material in mind when thinking about the adequacy of the system. Secretary of State contends the standard time period, 7 days, is plainly adequate to deal with all relevant matters. 7 days, our comment, 7 days is manifestly not adequate for RM, just enough for him to take the most basic steps of finding a solicitor and getting funding in place, but not to take any substantive steps beyond that. Not able to reduce even basic medical evidence until 4 weeks after the NOI was served, and comprehensive medical reports from the full statement took 8 weeks. And then we have similar points over the page. I won't take time now doing them. That's one of the purposes of the note. But we have got in the only detailed case that's available to the court for for examination of these procedural fairness points, because of the way in which they have been argued by an NGO whose points have been adopted by AAA. Now, then going back to my missing case, I think I have got enough time just to say a word about it. Going back to my missing case at the foot of the first page of the proposition, the academic material, we invite the court to take the academic material in two stages. One, look at what is a penalty. And the answer is crystal clear. If you go to Costello, not going to invite your lordships to go to it now, Costello, Unique Volume 19, Core Authorities Bundle, starts, the Costello section starts at page 3702, 3702, and the passage, which is crucial, that makes it clear that in any ordinary circumstances, what is happening here would be a penalty, is at 3708. And the passage in Hathaway on penalties is at page 3718 to 3719 of the same bundle. I did take your lordship through that on Tuesday. So is it right, the next, so this would be a penalty. Subjection to an inferior determination system would undoubtedly be a penalty in ordinary circumstances. Is it right that the Travo prevent removal of someone who would normally be the subject to a determination process in the UK to somewhere else, to a system set up for the purpose of facilitating their removal? Is that covered by the Travo? The answer is no. We simply invite the lordships to read Hathaway at page 3723 of the bundle. The argument I advanced on Tuesday and repeat is that, of course, Article 31 doesn't prevent removal because of the come directly requirement within the article itself. You can send the asylum seeker back to the first point of asylum, first country of asylum. But that is completely different from offshoring your responsibilities under the Convention to a system set up for the purpose of deterring others from making a particular journey. At the very least, that's free of authority. We say, as a matter of basic principle, plainly right that is a penalty prohibited by Article 31. And I repeat the answer I gave to the Lord Chief Justice, that in any event, that needs to be slotted into our submissions about, slotted into our submissions in the ASM skeleton about the shape of the Convention without Article 31. So, at a gallop, that's a rather important submission, but there it is. Now, then the construction of ICSA. The rhetorical question I ask at this stage is, are there two competing constructions? A learned friend says, crystal clear, unambiguous, you just read paragraph 6. You needn't read section 1 at all. Section 1 just introduces the schedule. I say that produces an answer which is contrary to all the rest of the material. So if we could just go to the app, my last, I am out of time, I know that, I've been saying that. We just go to the Act.
Could we just have the reference again, Mr. Gravel?
So, it's Unique Bundle 29, in the Authorities Bundle. And it is, the Act starts at 145. The Lordship also have to handle, bear in mind, paragraph 26 of our skeleton.
Yes.
Yes, skeleton. Our key submission is that there is no reason why, when you come to paragraph 6, there is no reference in the were the throat words of paragraph 6 relating to immigration is because that's crystal clear from section 1 itself. If you go to paragraph 6, which is at page 153 of the bundle, one way of looking at our submission on construction, reflecting paragraph 26 of the skeleton, is that it's axiomatic that paragraph 6 actually should be read as any other EU-devised rights, etc., relating to immigration cease to be recognised and available in domestic law. Because that's what section 1 says. The mistake we find in paragraph 26 of the skeleton is that the Divisional Court failed to recognise there was a critical connection between section 1 and paragraph 6. The effect of that, if there are two competing constructions, then there is no doubt at all what all the rest of the material points to. Secretary of State never thought he was touching the Procedures Directive or the Qualifications Directive, or all the other material, explanatory notes, answer to the Select Committee and so on, would have been different. The reason is that section 1 did the job. We haven't seen the drafting instructions or anything on that. Once you get to two competing constructions, then frankly we win. And on that note, I shall sit down.
Thank you very much. Now, Ms. Knight, we have 40 minutes left, which means everyone's going to have to be shorter than they hoped, and I'm particularly concerned for Mr. Gill, who comes at the end of this process, that he's not the one that suffers. So we all know that very fine advocates can always condense an argument when asked to. So
I hope to be able to live up to that reputation. I don't know if the court wants to hear anything from me on Mr. Hussein's point, my Lord, the Vice President's point about certification. It was advanced before the Divisional Court. It is in the AAA skeleton at paragraph 24. Though we do cite the authorities, they cite the authorities, and we did below. Yogathas, you want the reference. All the references are at paragraph 24 of the AA skeleton.
yes, well, we have those. Yes.
Test is found to fail. So that final question is still live, and we say that that's the question that could an independent tribunal allow the appeal on the basis of the material before it. Just there's one reference for the AS is that we did, along with other parties, try to adduce further evidence before the Divisional Court. There's again, just for the court's reference, it's bundle 31, tab 1, page 3 and 4, an order from Mr. Justice Smith refusing permission to adduce some expert evidence in country material, objective material, and expressly stating this is not the opportunity to treat this litigation as a country guidance and the tribunal saying which it is not. So there is a confusion, it seems, as to what the court...
Sorry, I mean, I think it was the submit.
sorry, yes, so that...
What were you reading from something?
So yes, it was...
Well, what were you reading from?
It's the order of Mr. Justice Swift, bundle 31, tab 1, page 3. And I appreciate that he may have been saying we didn't introduce...
Well, which paragraph?
Paragraph, so it's over the page at page 4. Okay, it's paragraph 2 and 3.
Well, should we just read those? Sorry. Can I just read those?
1, 2 and 3, the third witness statement, the report and the material.
Yes, well, it's 3, isn't it? That really makes your point.
Yes. And just for the avoidance of doubt, again, in our pleaded case before the Divisional Court, we were challenging the certification of the human rights claim. It's in the list of issues amongst other places, but it's also, of course, in the amended statement of facts and grounds in the claimant's grounds before the Divisional Court. So there's no doubt about that. And indeed, the submissions at paragraph 183 of the judgment are focused around the way that those were presented by myself and by Ms. Townsend for AAA. So those, that I think disposes of that point. In terms of Munjaz, I don't understand Mr. James's point, because he says it doesn't appear to have been cited earlier. Again, it was cited. I gave the court the references. It's AAA, Amended States Facts and Grounds, paragraphs 172 and 174 in the bundle. That's AAA core tabs 9 and tab 12. It's also in the skeleton argument, absolutely clearly, under a heading, Gillick, Ilias and Stirring, the legal framework, the very first paragraph refers to Munjaz. So there's no doubt that's paragraph 276, sets out the legal test there.
276 of?
276 of the AAA skeleton before the Divisional Court.
Right.
I think, my Lord, I mean, because Mr. Mullen-Friend says James didn't address the question, then I don't know if the court wants anything more from me, but my Lord Chief Justice asked the question about what was Munjaz, what was the issue in Munjaz, and it was a case where the claimant or the appellant was challenging whether the policy gave rise to a real risk of harm.
Yes, directly.
Directly,
yes, that's right. I think that was a point that Sir James did make.
Yes.
From memory.
So it doesn't affect us, it doesn't undermine the claimant's case or the approach here. We do note at paragraph 29, Lord Bingham didn't precisely say he was going to address how to evaluate the risk or the probability of the risk. So that may be a live question for other cases or going forward if we were going forward in this substantive case. My Lord dealt with this in A at paragraph 29. My Lord knows that very well. Just the observation about BF Eritrea. My Lord, again, in that judgment, along with Lord Sales, identified that it wasn't pleaded BF Eritrea on an Article 3 risk basis. So that is paragraph 72 of BF Eritrea. So we need to worry about that. The core question, I think, when coming back to listening to Sir James this afternoon as well as yesterday, is about the protection gap. We say there clearly is a protection gap in the policy for the reasons that we've identified. The rules say A to D. The policy says it's covering A to D. It is entirely silent on what appropriate means and how that intersects with the human rights claim. In our pleaded case at paragraph 118, we say there are no criteria for caseworkers as to how that should be done. That we say and said was unlawful. And Sir James's response, as I understood it, was following A. You don't have to have a policy that addresses everything. But if this is category 3 of A, then we say if there's an omission in the policy under category 3, you didn't have to have a policy, you have got a policy. Once you put the policy in, it's got a direct caseworker to all the relevant broad considerations. It doesn't have to set out, it may not even have to set out examples, but it doesn't actually refer to D2 at all in the policy, save to say that the rule exists. And looking at it in its context and how it would be applied under paragraph 47 of A, we say that it's insufficient. There's no reference in the investigation guidance to the discretion or the overlapping nature with what is called non-protection human rights claims. I think that's the matter which may be troubling my Lord the Vice President. And just to refer back to the position in EM Eritrea, this is a novel. The reason there's a difficulty with this is in terms of the structure of the decision making, is because in EM Eritrea there was a third country certificate that Italy was safe, statutorily safe, and so therefore all of the human rights issues were considered in the human rights claim. That hasn't happened here because for the reasons that we've just been looking at, which have got sort of the omission under 345 A to D in terms, or A to C in terms of the cross-cutting position between, for example, conditions or mental health collapse, which may intersect with access to the RSD process, and the points my learned friend Mr. Brown was just making about what happens to persons who fall out of the asylum system in Rwanda. That is not covered by the A to C criteria, and there's no guidance on A to D. So on the face of it, we say the policy is unlawful, and the decision letters support that approach. You don't have time to go to them. You also have the decision letters in AS, in the AS bundle, volume 12, and again, they're the last two documents in that bundle, and they show the inadmissible decision deals with A to C, and says your human rights will be considered decision than the final document in that bundle. Just an example of what we say could be considered under
well, is this a reply to Sir James, or is it a development of your original submission?
my Lord,
I don't wish to be too pernickety, but replies are for replying, not for repeating or
I
developing.
apologise. What might come under D2? It could be, for example, the denial of access to refugee family reunion, which was the way it was put in the Divisional Court, and we've had a reference from Mr. Binsky took me to that material as to the Rwandan approach. That's a kind of example that where discretion might arise again, along as well with the ordinary hard-edged medical cases. And the final point, and it is my final point, which is that my learned friend Sir James said that this case effectively collapsed into Mr. Kilroy's case about procedural fairness. We say that it doesn't, but even if it was relevant, you need to look at AS's submissions, which the Divisional Court invited. Following the Secretary of State's change of position, the Division Court invited all the claimants to make their own submissions on that. And ours are in Miss Kilroy's bundle, volume 4, 14, tab 14 and tab 16, pages 152 and 159 of the AA core bundle. And that sets out why we say there's a real risk of denial of access to the now individual case. And that, so Mr. Drabble described RM, but you do have a set of written submissions that don't have time to take you through, which set out the same points for AS. So I think those are my submissions. Thank you.
Thank you. Well, now, Ms. Kilroy, can I invite you to ensure that Mr. Gill has at least 8 minutes of the 10 that he was expecting?
Yes, I'm grateful. My Lords, although my learned friend does not formally concede ground one, that the court was wrong to find that there was no right at common law to make submissions on general safety, he didn't make any arguments to support that conclusion. And in my submission, for the reasons I explained yesterday, the court was wrong to reach that conclusion, and I do respectfully invite the court to allow the appeal on that basis. Instead, my learned friend argued that the issue is academic in practice because, firstly, he said, caseworkers will consider representations on general safety if they are made, and secondly, it's unlikely that they will be made after this court has ruled on the arguments on safety before it. In my submission, my learned friend is wrong to say the issue is academic. On the first question, it is no good caseworkers being prepared to consider representations if there is no time to make them. The reason the court below reached the conclusion it did on the law was because if there is a right at common law, then the Secretary of State would be required to ensure that the procedure gave a fair opportunity to exercise that right. It was the Divisional Court's view, expressed in oral argument, and I took you to the passages, that 7 days was obviously insufficient, even with the possibility of extensions. There should be a longer period plus extensions. That was the view it expressed in oral argument. And that was the argument advanced by all the claimants, including asylum aid. It was rejected on the basis that there was no right in law, and if the Divisional Court got it wrong on that question, then that is a live issue. In other words, is there enough time? Secondly, in my submission, it is not unlikely that representations on general safety will be made by individuals after the court reaches judgment in this case. Quite the opposite is true. Now, it may be true in an ordinary country guidance case that would be unlikely, but this, and the judgment that your lordships are being invited to make, is not an ordinary country guidance case. And that is not only because, unlike those cases, these courts have not had the advantage of oral or expert evidence. The reason it's not like an ordinary country guidance case is because the Secretary of State has invited the court to rule that Rwanda is safe, not because it's currently safe. She accepts it's not currently safe, and the UNHCR evidence on this is unrebutted by any for the Secretary of State. her case on safety rests on the promise that it will become safe in the future for those subject to the assurances, that the current position on lack of safety will change. My Lord, Sir James was asked yesterday if there was any evidence that any of those changes had already occurred. For example, whether officials had been trained, whether proper reasons were now being given, or even if anybody knew what proper reasons were, whether the jurisdiction for hearing appeals had been established, whether lawyers were available. And his answer to all those questions was no, but all had been promised by Rwanda in the future. That means in my submission that inexorably future cases will, if the court accepts the Secretary of State's defence of the scheme, be charged with examining for the first time the evidence as to whether the promised changes have occurred. In short, evidence will be immediately relevant in any future cases to see if the assurances have been complied with. Thirdly, therefore, respectfully, it is unreal to suggest, as my learned friend did, that individuals facing removal to Rwanda, either in the past or in the immediate future, would not want to make submissions on general safety if they have a fair opportunity to do so. They all sought to do so in these cases, albeit that there was not enough time to do that before the June decisions. And they will all seek to do so in future cases, relying, if they occur, relying on how the scheme transpires to work in practice. Now, I accept, of course, on behalf of Asylum Aid, that if this scheme is implemented, there may come a time in the future where the position on general safety is more settled. But we are, in my respectful submission, a very long way away from that position now. Fourthly, in my submission, the distinction between general and individual representations is impossible to draw in practice. My learned friend, Lord Panic himself, said by reference to EM Eritrea that you can't sensibly assess individual aspects of safety without considering the general safety of a country. In my submission, that is equally true of individuals seeking to make representations on their individual safety. They must be able to consider and address the general position in order to make effective representations on their individual facts. My Lord, turning to ground 2, Lord Panic did not either defend ground 2, the Divisional Court's conclusion that individuals do not require access to lawyers to make effective representations. Instead, he said that they had access in fact. He said that as soon as they were detained, they had access to a duty solicitor. My lords, if by that my learned friend meant that they could see a solicitor straight away, that is not correct. The evidence on access to solicitors is in Asylum Aid's Divisional Court skeleton argument at paragraphs 31.6 and paragraph 39 with references. In short,
which paragraphs?
31.6 and paragraph 39, and there are references in there which obviously I don't have time to either tell you or go to. In short, the detained duty advice scheme, which was not designed for the Rwanda scheme, is subject to well-known delays in accessing solicitors, usually of several delays, and even once accessed, it only gives people 30 minutes of initial advice. They then have to meet again at some later point in order to be given proper and full advice. That only adds to the brevity and unfairness of the 7-day period. But in any case, it's Asylum Aid's case that even if individuals did, which they do not, have access, on the whole, have access to solicitors straight away, those solicitors would not have the time to do everything that needs doing. That is the key issue in Asylum Aid's case. So, my lords, as a result of my learned friend's position on grounds 1 and 2, the critical issue that is before this court, which is advanced largely by way of my learned friend's, the Secretary of State's respondent's notice, is the issue that was before the Divisional Court, which is whether 7 days is a fair opportunity to do everything that needs doing. And my lords, again, without turning it up because I don't have time, paragraph 31 of the Divisional Court skeleton sets out with references to the evidence what needs doing. And it is a long list of tasks that a solicitor needs to do in the 7-day period.
If your time is short, haven't
Yes.
you really got to meet the point about flexibility?
I'm
So
coming
you
to
are
that.
coming to that.
I am coming to that. A long list of tasks, and I would ask you to look at Ms. McPherson's statement, Ms. Pickup's statement. The references are there with the specified paragraphs, and Mr. Hussein's third statement, those paragraphs that are identified in the skeleton. My learned friend says 7 days is enough in some cases, but does not identify any cases in which it would actually be sufficient to complete all these tasks. And indeed, throughout these proceedings, the Secretary of State has never once pointed to a case in which 7 days either would be or was enough. Asylum Aid's evidence to the contrary is in the table of evidence and decisions, supplementary bundle, pages 3 to 9, volume 15, which I've already taken to you. The Secretary of State's case, therefore, here as below, is that if it is not enough, extensions can be granted. My learned friend did not address Asylum Aid's evidence that extensions of time are often refused or ignored, and if granted, are granted for short periods. And that is set out in the extensions table, which is at the supplementary bundle, volume 15, pages 10 to 16. He also did not address the fact that the grant of extensions does not appear in the policy, so that caseworkers are not even told to consider it, nor are they told that they should be granted, that is, extensions, if fairness requires it. My learned friend suggested the reason it was not set out in the policy is to allow maximum discretion. But Mr. McCaskill's statement, which is the only part of the documentation in terms of evidence before the courts that deals with extensions, this is tab 15, sorry, it's volume 15, tab 15, paragraph 23 of his statement, pages 280 to 293. He does suggest that there are some criteria, albeit not set out anywhere. He says there must be a good reason and gives the examples that I highlighted yesterday: illness, trauma, lack of access to legal advice. There's no suggestion there that the good reason should be that fairness requires it. My learned friend suggested that the authorities of Detention Action and Refugee Legal Centre indicated that a scheme of this brevity, whose only safeguard was a claim of flexibility in the witness statement of an official, was structurally fair. In my submission, the opposite is true, and I would like to turn up Detention Action, which is at supplementary bundle 2, tab 25, page, and it starts at page 996. Sorry, it starts at
bundle 24.
Yeah. It's bundle 28.
Oh.
Tab 25, page, it starts at 1058.
Tab 25. Yeah.
Yes. Starts at 1058.
Yes.
I'm going to have to take it very fast, but can I just point out paragraph 11, there is a table which shows the timescales, and in short, the relevant time period from decision to the hearing of the appeal. You can get from adding things together, the first 3 rows together, and it's 7 working days. So in other words, it's a period longer than the period you're considering, 7 working days. And then at paragraph 19, the court addresses the types of hearings and the kinds of issues that the first tier tribunal considered, and highlights the fact it's necessary to produce evidence, corroborative evidence. At the end of that paragraph, the combination of a highly expedited timetable, the fact that the appellant is in detention makes this task very difficult. And then at paragraph 20, the court sets out a whole series of tasks that have to be carried out. And in my submission, I would ask you to read them and compare them to the tasks that I asked, that are set out at paragraph 31 of the Divisional Court statement by reference to evidence. And in my submission, there are at least as many tasks, if not more, in this scheme. And then, please, I would ask your lordships to note at paragraph 21 the difficulty caused by the fact that appellants are in detention and will therefore have limited access to their legal representatives is explained in the witness statement of Mr. Blakely. So detention is a further aspect, making it more difficult. You then see what the safeguards were in this system. At paragraph 38 is the conclusion. Sorry, I skipped over the paragraphs for the sake, but paragraph 24, you'll see that from there onwards that what is described as a system where the judiciary are involved and they have a duty to transfer out. And the further safeguards are explained further at paragraphs 31 to 36. I'm sorry, I've given you the wrong paragraph, which is why I've got confused. I do apologize. It's 34 where you see the duty to transfer out. And the Secretary of State submitted that the duty to transfer out was a complete answer. And you'll also see at 35 and 36 the further safeguards, appellants are for the most part represented by lawyers, and an appeal to the first-tier tribunal and beyond occurs after appellants have undergone a fast-track decision-making process which has been held to be lawful. So, my Lord, a whole range of safeguards, none of which are present here, and despite that, at paragraph 38, the court concludes that the timetable is too tight. That's 7 working days, and that the safeguard of independent and impartial judges instructed to transfer out on grounds of justice is not sufficient to deal with the problem, and they explain why that is at paragraphs 42 to 44. And one of 2 reasons are applicable. Just summarising, I'll have to ask your lordships to read it afterwards, but just summarising, 2 reasons are applicable here. The first is that it's difficult in that short period of time that the individuals had to identify what evidence they might like or might want to put before the tribunal. And the second, at paragraph 44, is that it is likely, as the court said, to put it no higher, that judges will consider the time limits to be the default position. And then just highlighting at paragraph 45, I mentioned this in opening yesterday, that the court found the time period unlawful, but did not consider it. This is at paragraph 45, the court's duty to prescribe.
Yes, you showed us that.
So, my Lord, by comparison with this procedure, there are no safeguards at all, no independent and impartial judges, no duty to transfer out, no selection process, no excluded cases, no guidance on extensions. I mean, there is nothing at all. And in my respectful submission against that backdrop, it is not possible to say that this scheme is lawful. And my learned friend also took you to Refugee Legal Centre, but skipped over all the unique aspects of that scheme, which again, in fact, meant that the cohort of people who were subjected to this incredibly tight timescale had already been pre-selected.
You made this point yesterday.
Yes, I mentioned that yesterday. So, my lords, in my submission, if schemes with as many safeguards as those in detention action and the Refugee Legal Centre are either unlawful or only just lawful and require a flexibility, elucidation of a written flexibility policy as a condition of refusing the claim, then a fortiori this procedure is unlawful and unfair, and it meets the criteria in A at paragraph 67, detention action, paragraph 27. So, my Lord, just turning to a few brief points on ground 4, which is provisional conclusions. Notice of intent.
This will have to be very brief.
Yes, it's a pro forma. It only tells people that they are being considered for removal to Rwanda, not why.
Well, these are repeating the submissions you made.
Well, it's just my learned friend suggested it said why.
I won't interrupt, but
yes,
Mr. Gill is giving me looks to suggest that he's becoming anxious.
I honestly have 2 more points. So ground 5. My learned friend's arguments on access to justice were expressly premised on individuals having been able to prepare the material before and having access to the material before the decision. That's why he said 5 working days was enough. But obviously that was not the case in this procedure. They did not have access to the material before because they didn't have enough time. And the Divisional Court said they didn't need to be given enough time. On ground 6, my learned friend didn't address the implications of the certification power and duty at section 19C of Schedule 3 of the 2004 Act and the forward-looking exercise that needs to be done. So the Divisional Court, when it reached its conclusions on what fairness required, did not consider section 19C, only the immigration rules, which, as you heard from my learned friend this afternoon, are solely concerned with the Refugee Convention and not human rights issues. My Lords, I will skip my conclusion and sit down at that moment.
Thank you very much indeed, Mr. Gill. 6.5 minutes left.
My Lords, it is the respondent's submission with great respect, which are utterly unrealistic and divorced from the reality of data protection law or human rights law. Firstly, a set of basic points. He failed to refer to the fact that there are 5 stages of data sharing, not just 2. See our skeleton argument, paragraph 8. Second, it is not just the case that we're looking at a formal thing such as what is sent and will they keep it safe. It's much, much more than that. It is about what is sent, what will happen to it, what further inquiries will be made there, and what protections and remedies will be there, which is where Schrems comes in. The note that I sent in seeking to respond to the Master of the Rolls and the Vice President, paragraph 9, refers to our skeleton at footnote 4. Please have a look at it, because what footnote 4 deals with is what Mr. Hopkins just papers over, and that's what this exercise is, papering over in the hope that the complexity will be so much people will not get into it. You know, he fails to recognize and connect the dots between Article 14 of the Rwandan law, the references are given in that skeleton footnote, which talks about ineligibility based on criminality. And how are they going to make these inquiries, but asking other people, possibly in other countries, possibly in respect of offences that he has committed in his own country, how are they going to do that and what are the protections that are going to be available? Which is why it's absolutely part and parcel of the Article 3 inquiries, which if anybody actually bothered to assess this with any detail, they would actually understand. And even if it doesn't rise to that level, as I've said in paragraph 12 of my note, there is still, by analogy with Article 3 and Article 8 argument, even if that doesn't work, there is the pure Article 8 argument. He mentioned Al-Ghazuli. If you look at Al-Ghazuli, which is volume 21, tab 52, page 2003, Lord Carnworth in the Supreme Court says in para 227, last sentence, even if there wasn't the risk of death, the death sentence, even if it wasn't there, the failure to comply with the data protection legislation would mean this couldn't be sent. We've explained why, in this note, why in my earlier submissions, which I won't repeat, why the sending of the data is intimately connected with the request to seek the consent.
It's intimately connected with the points you've just heard, but nobody seems to understand it. And I'll explain in a moment why. But since I'm not necessarily going to have too much time, let me deal with my main point first before I deal with that point about flexibility in the asylum aid context. And that is this. Structure of Chapter 5. Mr. Hopkins spent some time on this. If you care to look at the two Schrems cases, and Schrems was also, people told him he was mad. The data protection officer in Ireland rejected his complaint. Fortunately, he had a good Irish judge who referred to the Court of Justice where this issue then started opening up. You have those cases in the authorities bundle, volume, I've given you the citations already, and I'm not going to take time over them. Please read even if you read just the headnotes and the paragraph numbers that are cited there, you'll understand why the issues about protection are important. It was Facebook data, anodyne data. Ours is much, much more serious than that. Even in relation to that anodyne data, what they said is that there is no adequate inquiry that has been made. Never mind 45, 46 for a moment. No adequate inquiry that has been made to ensure, the word is ensure, never mind good faith or assurances, it's to ensure. Lord Justice Singh, binding legal instruments, the footnote in our skeleton argument, not these MOUs. No inquiries have been made to show that if the security agencies get their hands on this data and want to look at it, and you want to ask questions about it, what would be your remedies? There were gaps in US law. Everybody told Schrems, you're mad. Nobody's going to go for the argument that US law is completely defective. This is why President Obama then had to get up and say, look, we're not interested in looking at all this stuff. We're only interested in looking at a bit. Court of Justice would have none of it. Twice they struck down there were adequacy decisions under Article 45, but that's not the point. The point is about the test. What he pointedly did not refer to was Article 71 of the withdrawal agreement, which says where there is no adequacy decision, you've got to have essentially equivalent standards. That's what it says. If you read the Advocate General's opinions, and they're worth reading because they explain the law and the background, and all the blogs on this that everybody over Europe has been writing since Schrems exposed all this, you'll begin to see why the arguments about essential equivalent standards are so important. Never mind Article 3 risks. And this is what is going to skate over to the asylum aid points in a moment, which I'll explain. So, second point on hierarchy is this. It is not a free choice of 45, 46, or 49. Why on earth would Article 31F say what it does? Why on earth would Article 49 be described as a derogating provision? What is it derogating from? From Article 45, 46. It's derogating because it's an exceptional provision. Why on earth would the European Data Protection Board itself say that this is something you don't use routinely? Because you should be using 45 if you can. If you can't, try 46. If you can't do that, then you come to 49. And that's Court Authorities Volume 19, tab 16, 361, page 365, paragraph 2 at the top, page 371, paragraph 4, where they make those points. So this is all about hierarchy. You can't just jump to Article 49 and say, oh, we've got a free choice.
Well, that's your submission. So that's your submission and the difference between you on this point.
Absolutely.
Yes.
And he doesn't respond to my paragraph 53, which says, even if there is a choice, how do you rationally exercise one choice rather than another? If you've got a choice, do you not choose the method that maximizes parliamentary scrutiny and human rights? Asylum aid points. The reason why data is so important to notice is this. Articles 12, 13, and 14 require the Secretary of State to, before the data is taken, to give the notice to the person as to what will happen to it and for what purposes. The point of that is to give the chance to object, which is why Lord Justice Lewis said to me, rightly, you're in a stronger position than asylum aid, aren't you? you've actually got a statutory right to the notice. Yeah, I have. Not only that, what's the point of that notice? The point of that notice is to give the chance to object. Article, otherwise it's pointless.
Yes, well, I think, again, you're now repeating
My Lord, I
submissions
do have to
that
make this
you
point.
made.
I must protest. I've been cut
No,
down.
no, don't worry about protesting.
I'll be finished in 2 minutes.
But do respond to the points that have been taken by.
Yeah, I am trying to do that because what he's saying is that it was the flexibility point, and I'm entitled to respond to both to Lord Panic and to Mr. Hopkins. Both of them said that there is flexibility. Flexibility isn't the issue here. The point here is that never mind being able to ask for time later to extend the 7-day period. The point is the horse has bolted because the data has been sent and you haven't been given the chance to object before the data is sent, contrary to Article 21. And so all of these points that Asylum had made are absolutely posterior to my anterior point that you've got to have the notice for the data, because if you don't protect the data, how do you protect the individual? And it's that they knew that, which is why they said in their data protection impact assessment, you'll see it, that we're not going to give any notices until we've done all these assessments and made sure we're safe, and then they give the notices. So when you follow all that through, and their own data protection officer was more or less saying what I was saying, and they didn't, and he didn't address any of that. Once you recognize that point, this case, more than any other case, is what's anterior to all the arguments you heard from Mr. Hussain and from Ms. Kilroy, in order to show why it is you've got to take those steps, because if it is the essential underpinning to the removal decision. My Lords, it's a much more detailed case than anybody has given it credit, because they've been focused with their standard refugee law arguments.
Thank you. Well, you actually had your 10 minutes, Mr. Gill,
grateful.
And so I hope that was helpful. We will take time to consider our decision, and we'll produce judgments as soon as we're able to. I have read with interest and astonishment all sorts of speculation in the press about how quickly our judgments are going to be provided. You've given us a good deal to think about. You've also given us rather a lot to read. And so you will have to understand that it will take as long as it takes. But thank you all very much indeed for the obvious care that you've taken in providing us both with written and oral submissions. We're very grateful.
All right.